Automobile Association this morning. I'd like to set aside 5 minutes for rebuttal.
Sure.
I see by my clock, at least it's 10:15. I know that's just about right. Your Honor, this is a post-2012 Florida no-fault or PIP statute case, and specifically involves a subsection of that statute, section 627.736(5)(a)(3). That specific section was added in 2012, and we're going to talk about it in greater detail. What this case is not is a 627.736(5)(a)(1), where there's 5(a)(1)(a) through F. That's not what this case is. This is also not a 627.736(5)(a)(2). That part of the statute sort of creates a floor for reimbursement, if you will, by looking at the 2007 version of the statute and what the applicable statute says regarding reimbursement. So the issue before the court specifically is whether or not USAA properly applied 627.736(5)(a)(3) when it reimbursed for the services of an advanced registered nurse practitioner, or what's called an ARNP. And the reason that USAA reimbursed at that level is because the 2012 statute was specifically amended so that it did not prohibit insurers from utilizing Medicare coding and payment methodologies. Specifically, what 627.736(5)(a)(3) provides is it says it does not prohibit, but rather allows PIP insurers, and for that matter, insureds, of course, to utilize the Medicare payment methodologies when determining reimbursement of medical charges that were submitted, in this case, by an ARNP. So with that, the focus of the court is how would Medicare reimburse for the services of an ARNP? I don't think that's in dispute. All of the evidence shows that what happens under Medicare is they take the charges that would be.
Mr. Dutton, does it really focus on what Medicare would pay?
To an extent. And let me share with you what I mean by that.
Because I'm concerned that sort of overstates the use of Medicare for reimbursement purposes.
And this is what it does. It sort of mixes, if you will, the Medicare fee schedules. And then once those are established, determines how Medicare would reimburse for it. If you'll allow me just 1 second, Judge LaRose, and I'll explain that to you.
Please do.
And so if you look at the pertinent part of the statute, it specifically says subparagraph 1. And as I said, this is not a 627.736(5)(a)(1) case. And so it starts out by saying that subparagraph 1 does not prohibit an insurer from utilizing the Medicare, and I'm paraphrasing, payment methodologies to determine the appropriate amount of reimbursement. And the reason I read that is it doesn't say that the companies pay exactly like Medicare. What it says is that it may use the Medicare payment methodology in order, I'm going to read it again, to determine the appropriate amount of reimbursement. So they're not
the end result. Maybe I'm oversimplifying. I'm supposed to pay 80% of 200% of the Medicare, right? That's my starting point.
If you were under 627.5(a)(1,
that's my starting point. As I understand the history of PIP, that formula basically is a proxy for reasonable reimbursement.
Not exactly, again. And so let me share with you what I mean by that.
Well, let me finish off my thoughts so that you can, you can criticize my analysis completely. And when I then add the 15% haircut to the ARNP, I am basically coming up with a rate, a price which is lower than the proxy for reasonable reimbursement. So dissuade me from my thinking.
Sure. And it's this way. Let me start out, and as I did before the trial court below, with a brief history of the PIP statute. And I know, Judge LaRose, you're very familiar, and certainly you, Judge Northcutt. I believe that probably Judge Smith is the newest one to PIP land. But what happened back in the early 2000s, specifically in 2001, for the first time, the legislature installed fee schedules into the statute. Those were for MRIs and nerve conduction velocity studies. That stayed pretty much the law until 2007, when the statute actually repealed, and then it was reenacted and came back in, except that it added some additional fee schedule matters. But what it said operatively is this. It says the insurer may limit reimbursement to 80% of the following schedule of maximum charges. In other words, it says you may apply that ceiling. As this court's well aware, that came before the courts in the Kingsway Amigo case, and ultimately in the virtual imaging case, which went up to the Supreme Court. That was the 2007, 2008 version of the statute. What happened then, and we pointed this out to the trial court, is they were traveling under language which talked about the allowable amount under Medicare. And it specifically suggested or intimated, when applying those fee schedules, that you would look at the allowable amount under Medicare Part B. And what the courts turned around and said is, well, not really. And one of the cases that both sides cite is the case that went before the Second District Court of Appeal, and that was the Nationwide versus AFO case. In that particular case, what they did was apply the outpatient prospective payment system. And the court pointed out, well, allowable amount is in the 2008 version of the statute, doesn't really mean allowable amount under Medicare. And so we need to look at how much is allowed under the participating fee schedule Medicare Part B. That was in 2011. In 2012, there was also a case out of the Fifth District Court of Appeal, which is the State Farm versus SOC, SOCC case. And the issue in that case was the application of the National Correct Coding Initiative, or NCCI. Again, the court, following the same reason or rationale as the Nationwide versus AFO case, said, yeah, the PIP statute as then written speaks to the allowable amount under Medicare, but that's a different track, and it's not the Medicare participating fee schedule Medicare Part B. It was in specific response to that on a timely basis, because that's 2011, 2012, that, and this is in direct answer to your question, Judge LaRose, we were going under the fact-dependent method leading up to virtual imaging. We were going under the limitation of reimbursement method under virtual imaging. The company, the industry had to specifically elect one or the other, and could not, in the words of many of the courts and the conventional wisdom, come up with a hybrid method. Consequently, they rewrote the statute, but they added two other reasonableness tests, and that's what I was trying to get to. Number one is, in both the AFO case and in the SOC case, they could not use the Medicare coding and payment methodologies. And so the legislature specifically installed those into the statute so that insurers and insureds could do that. It also added a fourth methodology, and that's what's called the billed amount methodology. Now, that's certainly not before the court today. In fact, that was before the court in the accident and injury case over in the Fifth District, the Irizarry case. But this one specifically focuses on what the court was trying to do regarding evaluating the reasonableness of the charge by putting that language in there.
But as I understand the trial court's order, she was of the position that third sentence, I'll call it the third sentence, basically eliminates sentences 1 and 2. And I'd like your view on why that's wrong.
Sure.
She's trying, I think, to give effect to all three sentences.
Well, so you're looking at 5A3 in particular.
Yeah.
So she didn't suggest that this was a utilization limit, because utilization limits have been, if you will, foo-fooed by the courts because it limits.
Yeah, that just has nothing to do with utilization. I agree. I agree with you. You got me there. I'm fine.
Okay. The second point is it had to do with the scope issue. And we cited cases where, for example, if you look at Medicare, Medicare will not reimburse a chiropractor for doing things such as physical therapy. And we pointed that out to the trial court. So what the Florida statute was designed to do specifically, and if you look at 5A3, it says that an insurer that applies the allowable payment limitations of subparagraph 1. Now, I want to remind the court, if I may, that we're not traveling under subparagraph 1. We're traveling under 5A3. But it then goes on to say, must reimburse a provider who lawfully provides care and treatment under the scope of his or her license, regardless of whether such provider is entitled to reimbursement under Medicare due to the restrictions or limitations on the types or discipline of the healthcare providers. So there's no question that we reimbursed. And what that specific provision was, number one, directed to subparagraph 1. We're not traveling under that section. And then number 2 is we didn't disallow payment under the scope of this ARMP's license. We paid it. They're reimbursed. The challenge is how much was reimbursed. So when you look at and give effect to, again, reading the paragraph, Judge LaRose, however, subparagraph 1 does not prohibit an insurer from using the Medicare payment methodologies to determine the appropriate amount of reimbursement. So what the court essentially did was, in the way she wrote the order, render that language superfluous, as though it was meaningless, especially when you read the remainder of the order addressing the point that you've always got to reimburse at least 80% of 200% of the fee schedules. That would mean if something's going to pay less than 80% of 200% of the fee schedules, or 80% of anything under A through F, that it renders it completely out of the statute. And that's what she did. She wrote that section of the statute that was specifically put in there in response to Nationwide versus AFO, State Farm versus SOC, completely just wrote it out of the statute when the legislature tried to add, again, the third rail of applying the Medicare coding and payment methodologies. And the fourth rail, the billed amount, which again is not before the court today. So I'm not sure I answered all your questions, but I hope that I did as it relates to what the trial court did below and where the error is under the plain language of the statute. All you have to do is, number one, isolate subparagraph 1, which is where the appellee travels in their briefing to a great extent, almost exclusively. And then number 2, acknowledge, as I started out, this is a 5A3 case. So I hopefully that sort of answers the court's question and allows why I was trying to explain the historical perspective to the trial court and the evolution of this statute and what was intended in light of that 2011 case and the 2012 case. Moreover, when you look at it, one of the arguments that was made by the court, or one of the rulings of the trial court below, is again that the statute creates a floor and you can't go below 80% of 200% of fee schedules. That's not what it says. It says may limit reimbursement to a schedule of maximum charges, not minimum charges. And talking about absurdity, that would lead you to believe that the Florida legislature intended to say, oh, I don't think providers are getting paid enough. Well, that's certainly not been the initiative of the legislature since the year 2000, when the grand jury came out and said the medical charges by PIP providers are fraudulent, they're abusive, they're excessive, and we need to do something about it, starting with the evolution of the statute. But
you're down to 5 minutes, so use them as you please.
Your Honor, then I'll set aside my five minutes for rebuttal. Thank you so much.
Sure. Mr. Caldavia.
Good morning, Your Honors. May it please the court. I'm Dave Caldavia. I'm one of the many attorneys representing Dr. Crespo in this appeal. The trial court's summary judgment is correct and it should be affirmed. USAA's arguments in this case violate fundamental principles of statutory construction. When one part of a statute appears to have a clear meaning, if considered alone, but that meaning is inconsistent with other parts of the same statute, the principles of statutory construction require us to examine the entire statute and read all of its parts in harmony in a manner that gives meaning to all parts of that statute. USAA is inviting this court to read one sentence of the PIP statute in isolation in a manner that renders other parts of that statute completely meaningless. When you have two statutory provisions that are in conflict, the statutory constructions principles tell us that the specific provision controls the general provision. USAA is inviting this court to take the opposite approach and let the general provision of the PIP statute control the specific provisions.
Mr. Caldavia, let me ask you a question, and maybe my common sense approach just is at odds with how the statute reads. 80% of 200%, which I was sharing with Mr. Dutton, is sort of like the proxy for a reasonable reimbursement. Why would it be improper to give an additional 15% cut when I consider that the person who's performing the actual service has a lessened scope of practice than the physician?
Okay, let's answer that through the clear language of the PIP statute, Judge. And this is a very long PIP statute. You know, the PIP statute was adopted in 1971. It's been amended 50 times since 50 years ago. So on average, it's been amended one time every year. So it's very long and complicated. I've quoted it, the provisions at issue at pages 14 through 16 in my answer brief. I don't know if your honors have a copy of the brief or the PIP statute handy, but I think it's important to really look at this. So let me answer your question. It is, you say it's a proxy, but there's a whole list of specific charges, maximum charges, and Mr. Dutton likes to call them a ceiling. They're not really a ceiling, they're the fixed price. And we'll go through them. 5A1, if you have that statute handy, is where we're starting. And it is a substitute, it's an alternative method for the fact-dependent method that you find in 5A. There's no dispute in this case that 5A does not apply. USA's policy only adopted the 5A1 fee schedule method, and that's the only method that we're going under. So Mr. Dutton wants to skip over completely 5A1 and go straight to 5A3. So he's writing all these provisions out of the statute. But 5A1 says the insurer may limit reimbursement to 80% of the following schedule of maximum charges. So it can limit reimbursement to these specific amounts. So Judge LaRose, your 80% of 200% of Medicare, that is right in subsection A, 5A1A. But that only applies to emergency transport and treatment providers. They get 80% of 200% of whatever Medicare will pay. So whatever Medicare will pay to an ambulance driver, a PIP insurance company has to pay double that amount. But let's look at all the other different types of healthcare services and healthcare providers that the PIP statute identifies here in this fee schedule. Subsection B is for emergency service providers I'm sorry, emergency services provided at hospitals. They get a different, completely different fixed amount. It's based on 75% of the hospital's usual and customary. Subsection C is emergency services rendered at a hospital by a physician or a dentist. They get 80% of their usual and customary charges in the community. D, hospital inpatient services. They get 200% of Medicare Part A prospective payment. That's a specific just for them. Again, these are very specific. E, for hospital outpatient services, they get 200% of the Medicare Part A ambulatory payment classification. So then we're under F because we're non-hospital, non-emergency. Again, very specific provision here. For all other medical services, they get 200% of the allowable amount under. And then importantly, in 2012, part of the amendments was the subsection F was split into 3 Roman numerals. If you look at that session law, you'll see that F was split into 3 Roman numerals. We're going to fall under Roman numeral 1. So for all other medical services, 200% of, for us, the participating physician's fee schedule of Medicare Part B. Okay, so that's a specific fee schedule for everybody else, except if you fall under Roman numeral 2 or 3. Let's look at Roman numeral 2. Roman numeral 2 says Medicare Part B. It doesn't say the participating physician's fee schedule of Medicare Part B. It just says Medicare Part B if you're an ambulatory surgical center and clinical laboratory. So in other words, whatever Medicare would pay under Medicare Part B, under all their plethora of regulations and payment methodologies, coding methods, et cetera, if you're an ambulatory surgical center and clinical laboratory, you're going to get double what Medicare pays. But only if you're an ambulatory surgical center and a clinical laboratory. Mr. Dutton wants to lump us into that. He wants to add nurse practitioners into that category. And it really works the same way under 5A for emergency transport and treatment providers. It's broader than Part B. It says for you ambulance drivers, you're going to get 200% of whatever Medicare pays under whatever, possibility or permutation that Medicare would pay you under your factual situation. You're going to get double that. So Mr. Dutton's either trying to pigeonhole us under 5A, 1A or 5A, 1F, Roman numeral 2. But we're under Roman numeral 1. And so he wants you to skip all of that. Don't bother with any of these specific fee schedules. We're a 5A3 case here. Well, what does 5A3 say? 5A3 says, hey, when we're talking about 5A1, pay attention. These are some rules that apply to 5A1. So he wants you to skip 5A1. All right, so the first sentence really doesn't apply here. That talks about utilization limits. We all agree that this is not a utilization limit. The second sentence, though, does apply here. It says, an insurer that applies the allowable payment provisions of 5A1 must reimburse a provider who lawfully provided care or treatment under the scope of his or her license, regardless of whether such provider is entitled to reimbursement under Medicare due to restrictions or limitations on the types or disciplines of healthcare providers who may be reimbursed for particular procedures or codes. So that's a mouthful. But in Nationwide versus AFO, this court actually told us what that second sentence means. And so did the SOC decision, SOCC versus State Farm decision out of the 5th DCA. So let's talk about that for a moment. Mr. Dutton wants to say, oh, that only applies if Medicare wouldn't pay anything to a particular type of provider. No, that's one interpretation that you could get out of that, but it's not the interpretation followed by this court in AFO versus Nationwide, which affirmed Judge Barton's decision, which is a published decision. It was a class action, AFO versus Peak Property. I was counsel of record in both of those cases. Judge Barton explained, and this court affirmed, that that second sentence addresses situations when Medicare merely imposes restrictions and limitations on reimbursement. And in that event, the PIP insurer must reimburse the healthcare provider who lawfully provided the service, regardless of those Medicare restrictions or limitations. Now, Mr. Dutton wants you to think that, oh, well, that was all reversed by the by the 2012 legislation. That was the whole purpose of it. Well, there's probably 8 different staff reports published on that 2012 legislation. And oddly enough, the AFO versus Nationwide decision isn't mentioned at all in any of those reports. There are some cases that are discussed in those staff reports. If you go through them, you'll see that the legislature was very concerned about the Custer versus United Auto Insurance case, which involved examinations under oath. And it's whether an insured has to participate in that if the insurance company wants them to participate in an examination under oath. It's like kind of like a deposition before the lawsuit. And so because of the decision, the insurance industry did not like that decision. So they lobbied the legislature to tighten the screws on the insureds on those examinations under oath. There also is a discussion in the staff reports about all the case law that allows PIP lawyers to get a multiplier, a lodestar multiplier. And the insurance companies did not like that either, don't like the multipliers. So they lobbied the legislature hard to eliminate that from the PIP statute. And you see that in the PIP statute, and you see it discussed in the staff reports. No discussion about AFO, the Nationwide versus AFO decision, which logically says, look, the fee schedules are the minimum amount. How do we know that? Well, we know that because these are, 5A1 says, insurance company, you can reimburse the doctors to the following schedule of maximum charges. So if my law firm has a reimbursement plan for expenses and they say, Caldevia, we will reimburse your lunches at up to $20, and I turn in a receipt for $30, I know that I'm going to get paid $20. I'm not going to get paid 10 or 5. I'm going to get paid $20 because they're going to reimburse me up to $20. That's what this says. So it's not a ceiling. It's not something that you can play in between two numbers. It's one number. It's one number. Now, the SOC case versus State Farm, Mr. Dutton wants you to think that this 2012 legislation reversed that case too. But funny enough, the 2012 legislation was enacted in May 2012, but the 5th DCA's decision was issued in July of 2012, a couple, 3 months, two months after, and then there was a motion for rehearing. The motion for rehearing was decided in September of 2012. So I'm afraid that case was not intended to be touched by the legislature. What is the meaning? He wants you to believe that Judge Peroni gave no meaning to this third sentence of 5A3. Well, 5A3 says, first of all, that subparagraph 1, a list of fee schedules that are very specific to each and every type of healthcare service and healthcare provider, does not prohibit insurers. It doesn't authorize it. It does not prohibit them from using Medicare coding policies and payment methodologies, including applicable modifiers, to determine what the appropriate amount of reimbursement for medical services, if it's not a utilization limit, which we agree it's not. So it doesn't say you can, insurers, you can use this to determine a lower amount or a lesser amount. It says to determine the appropriate amount. Well, yes, you can use Medicare coding policies, especially for ambulance drivers. You can use any coding policy or payment methodology to pay an ambulance driver. You can also use any coding policy or payment methodology to pay an ambulatory surgical center or a clinical laboratory, as long as it's a Part B coding policy. So it has meaning, especially with respect to those two categories of healthcare providers. The legislature could have just said, and could have just eliminated, which is really what USA wants you to do. They could have just slashed all those subsections of 5A1, A through F, could have slashed them all and just said, you know what, PIP insurers from now on, you just pay 200% of whatever Medicare will pay. Because that's the bottom line where he wants you to go. Instead, he just wants you to ignore everything in those statutes. Judge Peroni says, we can't do that. We can't do that. There's plenty of other examples of the meaning of that third sentence, how it applies to use the Medicare coding policies, payment methodologies. They're written in my brief at pages 28 through 31. I can't go through them all, but there's plenty of examples in the published case law of meaning that you can give to that sentence without totally eviscerating all the other provisions that Mr. Dutton wants you to ignore. Mr. Dutton mentioned that the 2012 legislation is intended to do away with fraud, that there's fraud rampant in PIP. There's no fraud in this case by my client. If you want to see some fraud, why don't you look at the USAA's explanation of benefits in this case. It's at page 227 through 229 of the record. And when my client, Dr. Crespo, submitted his bill, USAA told him, here's the amount that we're going to pay. We're going to pay you $225.43. And the explanation says, per Florida statutes 627.736 5A1F, services, supplies, and cares are reimbursed at 200% of the applicable Medicare Part B fee schedule. Well, it's not. They slashed another 15% without even telling them. Without telling them, they said, oh, you're getting the full 200%, Dr. Crespo. No, they gave him 15% less. So if there's any fraud in this case, look to USAA about that, not Dr. Crespo. The abuse that's going on in PIP is more on the insurance company's end than on the healthcare provider's end, but certainly there's none in this case from my client. You know, Judge Peroni's decision really goes through and gives meaning to all parts of the statute, which is what we're required to do.
I'm assuming there are a lot of these in the pipeline, because
Yes, this is an important
I sort of
issue.
wonder how academic this may become depending on how the legislature ends.
Well, we've all heard that PIP is probably going away soon, but let me remind you that there's a 5-year statute of limitations on PIP claims. So regardless of what they do, let me suggest to you that there's 5 years worth of cases in here. And the trial court, Judge Peroni, certified this as a matter of great public importance, so it would skip over the circuit court. This court, if you look at the file, kicked it back and said, no, we don't want it. It went to the circuit court, and then the circuit court's jurisdiction expired. It came right back up.
It's just like a bad penny, Mr. Caldevilla.
It is. PIP is like, it's tough. It's a very complicated statute, but it affects a lot of people. And, you know, Dr. Crespo, Mr. Dutton wants you to believe also that this is a really great thing for the insured patients because their copayment is getting reduced by this 15% reduction as well. This is another example of where they just don't want you to read the statute. 5A4 specifically says that the reimbursement limitations do not apply to the insured. So it doesn't reduce the copayment amounts at all. So, and it also says that as long as the insurance company complies with 5A1, then the doctor can't balance bill the patient for the insurance company's portion of the bill, except for the copayment. So we can fully bill them for the copayment. And then when the insurance company underpays the doctor under the fee schedule, doctor has a choice. Well, I can just go after the patient for that, or I can make the insurance company pay what they promised to pay. Dr. Crespo did not want to sue his own patient for this $35 that USAA shorted him, and is shorting thousands of PIP claims. And let's be clear, there are class actions pending on this issue. This is a rarely important issue, and it doesn't apply to nurse practitioners. It applies to ops claims. Mr. Dutton wants you to think that the 2012 legislation was intended to reverse this court's decision in AFO versus Nationwide. Ask him, why is it that none of the PIP insurance companies are paying based on ops, which is a Medicare payment methodology for MRI providers. This court held that you can't use ops because it's not listed in the statute. You have to use the specific fee schedules, or you're not giving any meaning to those fee schedules. Now, Mr. Dutton says, oh, well, that case has been overruled by the legislature. No, it hasn't. If it had been, all the PIP insurers, all of them, would be using ops right now, but they're not. Same thing with the SOCC case. That was about the NCCI edits, they call them, which is another Medicare payment methodology. The PIP insurers are not using NCCI anymore. It hasn't been overturned. That's good law. There's nothing wrong with that law. And of course, the statute was amended after that, but it was intended to address the Custer case, intended to address the Lodestar multiplier. It could have been just as well intended to reverse these, or not to reverse, but to clarify these third DCA cases, Advanced Diagnostic and Millennium Diagnostic, where the healthcare providers were trying to, instead of getting the participating physicians amount, they were trying to get the limiting charge, which is an even higher amount. The third DCA clarified, no, it's the participating amount. Again, the legislature, by adding that third sentence, was saying, look, you can use Medicare payment methodologies to identify the appropriate amount, not to pay less. If you want to find out when you can pay less, go to 5A5. That's a new statute that the legislature inserted in 2012. And they said the only time that you can pay less is if the healthcare provider's billed amount is less than the fee schedule amount. That's
Yeah,
when
Mr. Caldebilla, my clock shows you at 20 minutes plus a little bit.
All right. Well, for these reasons and the reasons in our answer brief, we respectfully request that you affirm Judge Peroni's very well-reasoned decision. Thank you so much.
Thank you. Mr. Dutton to rebut. You're muted, Mr. Dutton.
I'm sorry, I tried to do that so that
I get it.
the paper in the background. My apologies.
No problem.
So let me sort of start at the top. Mr. Caldevilla mentioned all these insurance companies not doing this or that. That's, first of all, it's not a record in this case. But the truth of the matter is that they are applying the Medicare coding and payment methodologies, not just the ARNP PA physician's assistant, but also, for example, we've given you a bunch of the examples in our briefing. Let me give you one, the multiple procedure payment reduction, which is called MPPR. That's widespread throughout the state. That's a Medicare coding and payment methodology. And so to adopt the plaintiff's argument, all those cases that are out there, to include ones from the appellate courts, according to the appellee of this case, is wrong. The fact is that they're right. And so when this court renders an opinion in this case regarding ARNP, it's also rendering an opinion as to any other Medicare payment methodology. That would include MPPR, that would include outpatient prospective payment system, that would include NCCI, that would be the multiple surgical reductions. All of those are Medicare payment methodologies. And what he's asking to do, and what the plaintiff in this case is asking this court to do, is with the swoop of a pen, wipe out that language that the legislature specifically put in there to bring about the cure. So let me ask the court to look at that. Secondly, he wants you to ignore that part of the statute that says you need to look past subparagraph 1. It says it in multiple places. For example, as I brought up earlier, it brings it up in the scope part, where it says an insurer that applies allowable payment limitations of subparagraph 1. And the pertinent part here is where it says, however, subparagraph 1 does not prohibit an insurer from using Medicare payment methodologies. Well, what the plaintiff wants you to do in this case, what the appellee wants you to do in this case, is specifically use paragraph 1 to prohibit the insurer from using the Medicare payment methodologies. It's the exact opposite to the plain language of the statute. Number 3, he brings up a point that 5A1, and look at all of the, when you're under that part of the statute and how it plays. But that's why they amended it, because we didn't fall under 5A1, 1A1 through 1AF. Next, he brings up the fact that the nationwide AFO and the State Farm versus SFC cases, and he makes it sound like those cases are scope cases. Neither one of those are scope cases. They both turn upon the same statutory issue, And that is under the old statute before the 2012 version, what the companies were doing is specifically looking at this language, sub F. For all other medical service supplies and care, 200% of the allowable amount under the participating fee schedule. In those cases, with the Nationwide versus AFO case, they were applying OPS. In the SOCC case, they were applying NCCI. And that's exactly what they were responding to, because the language in the statute was not sufficient to allow insurers and insureds to pay under the Medicare coding and payment methodologies. There was also a discussion about staff report. And there is a staff report, and although it doesn't specifically refer to the Nationwide versus AFO case and so on, it does talk about this. It says medical reimbursement. Medical providers and entities may charge insurers and insurers only a reasonable amount for services and care. Insurers that provide reimbursement under the schedule of charges may use all of the Medicare coding and CMS payment methodologies, including all applicable modifiers, to determine the appropriate amount of reimbursement. So while they didn't cite a case, they certainly made it clear what they were intending to do in the staff report. Also, Mr. Calavia pointed out that when the statute uses does not prohibit, that doesn't mean it authorizes. That's quite a stretch of the statutory language, because if you're not prohibited from doing it, then you can do it. In this case, that's exactly what the legislature intended to do. When I talked about fraud, I was talking about what the grand jury that was impaneled in 2000. But as it relates to what they did in the EOR, EOB in this case, that's not what we pay under. We pay under the statute, we pay under the policy. And in part, it's a two-step. You got to look at the fee schedules and then multiply that under the Medicare payment methodologies to get to the 85% multiplied times 80%.
Okay, Mr. Dutton, you're at the end of your rebuttal time.
I appreciate that, Your Honor. And my apologies for running over time.
You're good.
Trying to just get my legs up under us, because starting off an hour early, and certainly be a little behind where I had hoped to be when I sat in this chair.
I once presented an argument that I didn't have on my calendar as a lawyer. So there you go.
Well, Judge, I remember presenting an argument with you in the Supreme Court years and years ago, probably 20, 25 years ago, on the liquor liability statute.
Yeah. Oh, yeah. That was fun. All right.
Not so fun for my client.
Well, ultimately,